Good morning, everybody, and welcome to our employment law webinar about protected beliefs in the workplace and where we are now, particularly following the Higgs case. I'll be speaking to you today with my colleague Lorna, who's on the screen now.
Hi.
And there's a couple of housekeeping points to make first. The first is that the session is being recorded, and you'll get copy slides and a copy of the recording, which will come out sometime early next week. The second is that there will be space for questions at the end. We probably won't take any as we go. We'll deal with them at the end. And any questions, if you could put them in the Q&A box rather than the chat box, and we'll be able to pick them up. The chat box is there, I understand, for technical problems. So if you have any of those, pop them in the chat box. That's right, and someone will pick those up. Okay, so we'll move on now, and I'm just going to look at the overview first. So what we're going to cover today, just a quick summary. The key facts and the outcome of the Higgs and Farmers School case. Understanding when and how the expression of belief may become inappropriate. What the judgment means for disciplinary action and reputational risk. How to respond fairly and proportionately to belief-related complaints. And the role of social media policies in setting clear expectations for staff. So Lorna is going to set us off on that. I'll hand over to you now, Lorna.
Thanks, Michael. So as Michael said, in today's talk, we're going to be looking at where we are now in relation to protecting religion and belief in the workplace, particularly in light of the recent Court of Appeal judgment in Higgs and Farmers School. But before we look at the specific case, it's helpful just to take a look at the legal framework that's being applied in this case. So, as I'm sure you'll all be aware, the Equality Act 2010 protects against discrimination on the grounds of a number of protected characteristics. And one of those protected characteristics is religion or belief. And for these purposes, religion means any religion, and a reference to a religion includes a reference to a lack of religion. And a belief means any religious or philosophical belief, and a reference to a belief includes a reference to a lack of belief. And as you will also know, the Equality Act protects against various forms of discrimination, including direct and indirect discrimination. But one key point to note is that direct discrimination under the Equality Act cannot usually be justified, whilst indirect discrimination can be justified where it is a proportionate means of achieving a legitimate aim. And the wording of Section 13 of the Equality Act, which is the definition of direct discrimination, is clear that direct discrimination occurs where, because of a protected characteristic, a person treats someone less favourably than it treats or would treat others. So this would, on the face of it, seem to prevent direct discrimination only where the less favourable treatment is directly because of the person's religion or belief. However, Article 9 of the European Convention of Human Rights gives the right not only to hold a protected religion or belief, but also to manifest that religion or belief. And the Human Rights Act 1998 requires courts and tribunals to interpret a domestic legislation in a way, so far as is possible, which is compatible with the European Convention on Human Rights. And that means that the Equality Act must therefore be construed as protecting not just the right to hold a particular belief, but also to manifest it. But it is important to note that under the European Convention of Human Rights, the right to hold a religious or other protected belief is an absolute right, whilst the right to manifest that religion or belief is a qualified right, which may, in certain circumstances, be limited. And in particular, the right to manifest one's religion or belief may be restricted if it is necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. So, over the years, we've had a number of cases which have considered how the Equality Act should be interpreted in order to give effect to this qualified right to manifest protected belief. And what amounts to a manifestation of a belief was clarified over 10 years ago now in the case of Awida in UK, which you may recall was the British Airways case, which involved the air stewardess who wanted to wear a cross in breach of their uniform policy. And in that case, it was decided that provided there's a sufficiently close link between the action and the belief, then that's likely to amount to a manifestation of the belief. There's no requirement that the action must be a specific rule of the religion or anything like that. And that case also confirmed that although manifestations of belief are not expressly referenced in the Equality Act, if an employer limits an employee's ability to manifest their belief in the way they wish, then that employee may bring a claim for discrimination, including a claim for direct discrimination. And what we then had was a series of cases which considered whether an employee who's disciplined or otherwise treated less favourably for expressing their beliefs would be directly discriminated against. And many of these cases have involved employees expressing gender critical beliefs, which since the Forstater case have been clarified as constituting protected beliefs. And in these cases, a trend has begun to emerge where the courts and tribunals would sometimes conclude that an employee who had been disciplined or otherwise treated less favourably for expressing their beliefs had not been unlawfully directly discriminated against on the basis that they'd manifested their belief, but rather the tribunals would say that a distinction could be drawn between the belief and the manifestation of the belief, and that it wasn't necessarily directly discriminatory to treat an employee less favourably for manifesting their belief in a certain way if the way in which they'd manifested their belief was inappropriate. And as this trend's developed, the tribunals seem to be suggesting, therefore, that employers could sometimes be justified in treating an employee less favourably because of the way in which they'd manifested their beliefs. And this raised the question as to whether an objective justification defence was being brought into a direct discrimination claim based on manifestation of religion or belief almost by the back door. And it was in the context of this line of cases that the case of Higgs and Farmers School was brought. And the Court of Appeal decision has now provided some further clarity in this area. So if we can move to the next slide, please. Thanks, Michael. And we'll now just take a bit of a closer look at the case itself. So Mrs. Higgs's case, like a lot of this line of cases, has involved some gender critical beliefs. Mrs. Higgs was a Christian, and as stated there on the slide, Mrs. Higgs believed that gender is binary. She did not believe that someone could change their sex or gender, and she did not believe in same-sex marriage. And it's been clear since the Forstater case that these beliefs qualify as protected beliefs. Now, Mrs. Higgs was a pastoral administrator and a work experience manager at Farmers School. She worked with secondary school pupils and also had some contact with their parents. And the school received a complaint from a parent about Miss Higgs's Facebook posts. Now, the initial post that was complained about was a reposting of another post written by someone else, which related to the teaching of same-sex relationships in schools and the teaching that gender is a matter of choice. In one of the articles which Mrs. Higgs had reposted, the article described gender fluidity as a perverted vision and its teaching as a form of child abuse. And it criticised LGBT plus education, saying that the LGBT crowd, with the assistance of the progressive school systems, are destroying the minds of normal children by promoting mental illness. And these posts had been reposted by Mrs. Higgs on her personal Facebook account, which was in her maiden name and contained no reference to her employer. And she'd reposted the article with the statement, "Please read this, they are brainwashing our children," and suggested that people sign a petition. The parent who raised the complaint said that the posts demonstrated that Mrs. Higgs held homophobic and prejudiced views against the LGBT community. Mrs. Higgs was suspended, and following an investigation and disciplinary process, during which she denied holding homophobic or transphobic views, she was summarily dismissed for gross misconduct. The school found that Mrs. Higgs had breached the school's code of conduct and that the fact that the one parent who had complained had taken offence at her post was evidence of discrimination. And it also concluded that there was a potential risk of harm to the school's reputation. So following her dismissal, Mrs. Higgs raised a claim of direct discrimination and harassment in the Employment Tribunal, alleging that she'd been dismissed because of her protected beliefs. So if we could just move on to the next slide, please, we'll look at what the courts decided. So in the first instance, the Employment Tribunal held that Mrs. Higgs' beliefs were protected, but it found that Mrs. Higgs had not been directly discriminated against or harassed because of those beliefs. Rather, it held that she had been dismissed because of the inflammatory language used in her Facebook posts, which the school were concerned could have led readers to believe that she had homophobic and transphobic beliefs, which would not qualify for protection under the Equality Act. Mrs. Higgs appealed to the EAT, and the EAT allowed her appeal. In reaching its decision, the EAT held firstly that the tribunal had failed to engage with the question of whether the Facebook posts were a manifestation of Mrs. Higgs' beliefs. In answering that question, it said the tribunal firstly needed to apply the test laid down in OOIDA, which I talked about earlier, and consider whether there was a sufficiently close or direct nexus between Mrs. Higgs's protected beliefs and her Facebook posts. And then, if the tribunal was satisfied that the posts were a manifestation of Miss Higgs's beliefs, it had to determine the reason why question. And this meant determining whether the school's treatment of Mrs. Higgs was because of the manifestation of her belief, or rather because she had manifested her belief in a justifiably objectionable way. And it reminded itself that based on that current chain of case law that had developed, that where the reason for less favourable treatment is the fact that a claimant holds or manifests a particular protected belief, it is direct discrimination. But that where the reason for the less favourable treatment is that the claimant has manifested that belief in some particular way to which objection could justifiably be taken, then it is the objectionable manifestation, not the belief itself, which is treated as the reason for the treatment complained of, and so is not necessarily directly discriminatory. It added that if the manifestation of the belief is not sufficiently objectionable as to justify the action taken against the employee, then this cannot sensibly be treated as separate from an objection to the belief itself, and therefore it will be directly discriminatory. And it further stated, in line with case law, that whether an individual's manifestation of their belief is appropriate or inappropriate should be tested by what it called a proportionality assessment, balancing the claimant's freedoms against the freedoms of others. It held that in this particular case, the tribunal had failed to carry out any proportionality assessment. And so what it did was remit the case back to the tribunal to be reassessed and determined in line with that proportionality assessment. However, in the interim, the claimant appealed to the Court of Appeal, arguing that the EAT should have upheld her claims rather than remitting them back to the tribunal. And the Court of Appeal allowed Miss Higgs's appeal and substituted a finding that Miss Higgs's dismissal constituted unlawful direct discrimination on the grounds of religion and belief. And in reaching this decision, the appeal held that dismissing an employee for expressing a protected belief to which their employer or a third party with whom the employer wishes to protect its reputation objects will be unlawful. Following the line of case law, it concluded that a dismissal motivated by the objectionable way in which the belief is manifested will only be lawful if the employer can show it was an objectively justified, proportionate response. And the Court of Appeal held that if this case had been remitted to the tribunal, then the tribunal would have been bound to find that the dismissal was not objectively justified and was therefore directly discriminatory. Now, in reaching this conclusion, the court found that although the school was entitled to take some objection to the posts because of the offensive language used towards gay and trans people, and because the context of sex education in schools was relevant to Miss Higgs's work, some objection could be taken. But despite this, it held that the decision to dismiss her was unquestionably a disproportionate response to this. And in support of this conclusion, the Court of Appeal found that Miss Higgs's posts were not, in their view, grossly or gratuitously offensive. It said that the language to which the school objected was not Miss Higgs's own words, but rather the words of others that she had reposted, and it found that it would have been evident to readers that this was a repost, not her own original words. It noted that Miss Higgs had also made it clear to the school during the disciplinary process that she did not agree with the language used, which was relevant to the degree of her culpability. The Court of Appeal also found that there was no evidence that the reputation of the school had been damaged. It noted that the disciplinary panel's main concern had been about potential future damage, and, in its view, there was no possibility that readers of the Post would think that Mrs. Higgs's views represented the school's views. They therefore concluded that any reputational damage was limited to a fear that Mrs. Higgs would express homophobic or transphobic views at work. And whilst the court accepted that the school's reputation in the community could have been damaged if that fear had become widespread, it concluded that the risk of this happening was speculative at best, since the posts were from her personal account in her maiden name and made no reference to the school. And the court also found that there was no evidence that Miss Higgs's work at the school had been affected by the views expressed in her posts. It noted that she had an exemplary work record for the past 6 years, had not exhibited any discriminatory attitudes towards pupils, and in its view, there was therefore no reason to doubt that her concern was specifically about the content of sex education in primary schools, and no reason to doubt her assertion that she wouldn't treat gay or trans pupils differently. Now, this may seem like a slightly surprising decision to some, but the court was at pains to stress that employers do not have a carte blanche to interfere with an employee's rights to express their beliefs simply because some third parties might find those beliefs offensive and may think less of the employer for employing them. But similarly, it's stressed that employees do not have a carte blanche about what they can say in public or how they may say it. Rather, it said that the characteristics of an employment relationship may entitle an employer to impose some limitations on an employee's rights to manifest their beliefs where it has a legitimate interest in protecting its reputation. But it said the extent to which an employer may be justified in doing so depends very much on the circumstances, and any interference must be proportionate. And in assessing proportionality, the court noted some key considerations. Firstly, it said that the subject matter of the belief will be relevant. It said that an expression of views about matters which have nothing to do with the employer's business will be less likely to damage the employer's reputation than expression of views on matters which are central to its business. Secondly, it said that the way in which the beliefs are expressed will also be relevant, and commented that even where a belief is protected, it may be reasonable to censure an employee for expressing the belief if the belief is expressed in a publicly inappropriate way. However, it's stressed that the threshold for offensiveness should be set highly and that protection should not be lost simply because an employee has expressed themselves intemperately. And thirdly, it said whether it is clear that the views expressed are personal rather than the views of the employer is also a relevant consideration. The court also expressly warned employers against unlawfully stereotyping an employee's beliefs, such as by labelling someone who holds gender critical beliefs as transphobic. Now, we understand that permission to appeal the Court of Appeal decision to the Supreme Court has been sought, but whether that appeal is going to be allowed is not yet known. So for now, what is clear is that while the words don't expressly appear in the Equality Act, it is necessary for us to read Section 13 of the Equality Act as incorporating some requirement to objectively justify less favourable treatment of an employee where the treatment results from an objectionable manifestation of their belief. And that means that employers are going to have to very carefully balance the rights of employees who hold protected beliefs that conflict with the beliefs of others. I'm going to hand over now to Michael to talk more about that. Thanks.
Thank you very much, Lorna. Hopefully, I'll be able to move the slides on. There we are. So, what does all this mean? Well, the school, in the Higgs case, didn't discipline and dismiss Mrs. Higgs because she'd expressed her religious views. They did it because the disciplinary panel concluded that the way her views were expressed was objectionable and put the reputation of the school at risk. And as Lorna's been describing, the Court of Appeal disagreed with that, finding that her comments were not grossly offensive and there was little evidence of reputational risk. This meant the dismissal was disproportionate and discriminatory. So when will the expression of a protected belief be inappropriate? Well, the first thing, and really important thing, is that context really matters. And as Lorna went through just now, the Court of Appeal identified 3 areas really key to consider: the subject matter of the expression or opinion of belief, the way in which the beliefs are expressed, and third, whether it is clear that the views expressed are personal to the employee or whether they could be seen as the views of the employer. And all of those points are really important in the Higgs decision. I think another point worth noting is whether there's any evidence of the expression of belief having an impact on the individual's ability to do their job. So context, in any case, I think is going to be really key. The next point there is public versus private expression. And generally, it'll be more difficult to take disciplinary action against an employee where they've expressed their views privately and without any outward link to their work. This might well make it more difficult to take action in respect of social media posts on private closed groups, even where they've generated complaints, as was the case in Higgs. However, it's important to note and remember that it can be proportionate to take action in respect of private expressions of belief outside of work, particularly if they become public and linked to the employer. And again, that circles back to how context is so important. It seems to me to be fair to remind employees in policies that they should be mindful of their online presence and potential impact it might have on their role at work. So in the end, it's all about balancing rights, the third point on this slide, and something which Lorna covered as well. Employers must balance the employee's right to manifest their beliefs with the rights of others not to feel harassed or discriminated against. This means that expressions which are objectively offensive or discriminatory may be deemed inappropriate, even if they stem from protected belief. But looking through the facts in the Higgs case, obviously there's a lot of careful consideration that needs to be gone through first before disciplinating or dismissing. What does this mean for disciplinary action and reputational risk? So the first point there is objective justification is required. Employers must have clear, objective reasons for taking disciplinary action related to the expression of beliefs. Higgs makes it clear that perceived reputational risk alone is insufficient. There must be evidence of actual or likely harm. The final point on the slide is that proportionality is key. Any disciplinary measures must be proportionate to the alleged misconduct. Dismissal should be a last resort, considered only when less severe sanctions are inadequate. So there's an example of this the judges gave in Higgs, was that the school could have easily made it clear that Mrs. Higgs's views were her own and not the school by issuing a statement to the parents, for example. So looking onto the next slide, responding fairly and proportionately to belief-related complaints. And the first thing there is a thorough investigation. And obviously that's conducting a comprehensive and impartial investigation into any complaints regarding the expression of beliefs. So be careful not to prejudge, stereotype, or jump to conclusions, even if the expression of belief seems offensive in the first instance. Make sure that managers don't send each other emails or emails to the person raising the complaint, criticizing expressions of belief before any investigation has taken place. Take a moment to think about whether suspension or disciplinary process is appropriate in the circumstances before setting off. The judges felt in Higgs that they weren't and made comments that potentially the disciplinary route was the wrong route. Consider the intent, context, and impact of the expression in question. The next is engaging in dialogue. Where possible, engage with the employee to understand their perspective and provide guidance on appropriate expression. Consider what would be a proportionate response to the expressed belief and don't automatically jump to disciplinary sanctions, although of course they may be relevant in some situations. Finally, document decisions, keeping detailed records of the investigation process, findings, and rationale for any actions taken, in particular around proportionality and evidence of reputational damage. And keeping those sort of documents and records will be really important when defending any legal claims. So moving on to look at policy considerations, and in particular the role of social media policies in setting out expectations for staff. So align policy to the organization's values, ethos, and expectations. I think it may be useful to expressly set out an organization's values in a document and refer to that document in other policies. Set out clear guidance on what the employer considers acceptable and unacceptable behavior, potentially both inside and outside work and on social media. Explain the relevance of personal social media to professional reputation. Acknowledge individual rights to hold protected beliefs, but explain requirements in terms of posting about beliefs in a way that could cause the employer or the individual reputational damage. And lastly, make it mandatory to comply with social media, an organization's social media policies, and keep a record of staff who have read and agreed to the policy. So you might mention social media policies, for example, in contracts of employment, or you might have an induction program which carefully records that they've been read and understood. So that's the final slide that we've come to in the discussion around Higgs and expression of beliefs. And we're going to move on to answer some questions shortly, which have come through in the Q&A. But the first thing I was going to do is just talk very quickly about the sexual harassment changes in October last year and how employers are under a positive duty to take reasonable steps to protect staff from workplace harassment. And ensuring compliance isn't just about policies, and I'm sure you're all aware, it's all about fostering a culture that actively reduces risk. Updated EHRC guidance highlights the importance of carrying out risk assessments to identify vulnerabilities and implement appropriate safeguards. And so how can VWV help? Well, we've got some bite-sized learning, online training courses, bespoke in-person virtual training, and workplace culture strategy to support a support package which we can provide. And it'd be helpful if you could just let us know on the poll, which I think you can see, whether or not you'd like to be contacted with more information about those services. So I'll leave that open just for a little while people have a chance to respond. And in the meantime, just going to see if there are any questions come through on the Q&A. First one is, please could you confirm the case being spoken about relating to manifesting a belief so I can carry out some further reading? Well, that's hopefully you've got that now through there, which is the Higgs and Farmore School. And there are quite a few articles and other things written online, so I'm sure that you'll be able to find that relatively easily. The next question is, if the ET felt disciplinary was the wrong route, what would they expect? Well, I think that is a difficult question. And I think when one looks at the facts in Higgs that Lorna went through, most of us would see quite a lot of the things which Mrs. Higgs was reposting as potentially problematical for someone working in a sort of counselling function within a school. And one can understand why the school took the route it did. What the Court of Appeal seems to be saying is they should have taken a step back first, I think, to assess what she'd actually said, what the impact was on the school in an objective way before deciding the route to go down. I mean, had they done that and decided reasonably to start a disciplinary, perhaps they would have been in a better position. I don't know if you've got anything to add there, Lorna.
No, only to say I think there was a suggestion that possibly it could have offered the employee some guidance first as to why it considered her posts were objectionable, and given her some guidance as to how she might more moderately express her views. And I think the court thought that if that had happened, and if she had still persisted in expressing her views in an inflammatory way, then it might have been justified going on to a disciplinary process. But again, I think it was thinking more along the lines of then it would be a warning rather than a jumping to a dismissal. So yes, just a much more moderate approach, I think, is what the Court of Appeal expected.
Yeah, and I think what took people by surprise a little bit was the court's views around the potential of reputational harm, which a lot of employers have relied on in the past in relation to these issues. And the Court of Appeal being very sceptical about that and wanting evidence about it rather than the potential of harm. So that's something we need to look at. So there's another question that's come in, which, do you think it may have been a different ruling had the school been more robust in considering the proportionality test and documenting the rationale sufficiently? Well, that is an interesting question. I mean, I think in theory, yes. Had a panel gone through that thought process, yes, but the problem might be for the school is that the Court of Appeal was so clear that her actions had fallen short of a dismissible offence in their view. And whilst courts are not supposed to substitute their view, the sort of flavour of the ruling is that she didn't really get anywhere near dismissal with these things. I don't know what you think, Lorna, on that.
No, I entirely agree. It seems and I think it seems at odds with quite a lot of the previous case law we have had, where I think the courts have tended to find objectionable, manifestation of belief. They've accepted the employer's reasons as to why it's an objectionable, manifestation. Whereas this seems to have reversed the trend quite a lot and basically said, actually, people don't have a right not to be offended, and just because you've offended someone, that doesn't give your employer a right to dismiss you. Essentially, I think it's sort of taken a very different tack, I think, to some of the previous cases, but I think is something that we're all going to have to be aware of as employers going forward, that we really will need to undertake that proportionality assessment, take a step back and a breath and think, what is it? Is it really proportionate for us to be dismissing or even disciplining in the circumstances, really.
Mm.
Yeah.
And there are some cases in the past, quite a lot of social media cases, which weren't about expression of beliefs, so they are slightly different. But in those cases, there was an emphasis about companies which had made expressions of ethos and brand importance very central to their policies. So certain tech companies were very careful about their brand and about how they should be spoken about in public and express that fairly clearly in their policies. Other companies were not so picky about it, and the case law around those non-discrimination cases was about, well, if it's clear in the policy, then they could take more strident action against employees who infringed it than people who hadn't been clear in their policies. If we transfer that across to the expression of beliefs, obviously you can't have a policy which allows you to discriminate. But nevertheless, I think having policies which very clearly set out what's important to you as an employer and why it's important will assist, won't they, in potentially taking more robust action. Again, noting that you can't discriminate because your policy says so. Okay, we've got a few more coming in, so we've got time for those. So excuse me while I lean in, my eyes aren't good enough to read them further out. So what key considerations might we give to a situation where an individual who is responsible for public media engagement with students expresses specific views in relation to the Israel-Palestine conflict in such a way that brings them into issue with the police for their conduct? Such views were expressed publicly on Instagram posts for themselves and others, and also via personal social media pages. Well, what I think we can't do is go into the rights and wrongs of views on the Israel-Palestine conflict, because it's such a difficult point. But it's a really good question. Somebody there, I think the underlying point is somebody whose job it is to be responsible for social media, expressing controversial views, which may well fall within, may well be protected, or the underlying view might be protected, depending on what it is. And the expression would then be protected potentially, and whether it would be disproportionate to discipline or dismiss someone in those circumstances. And I suppose from Higgs, what we've seen is the bar has been raised. So perhaps pre-Higgs, you might be thinking, well, someone in that position, you might be in a fairly good position to say, well, actually, you're impacting quite heavily on our reputation for impartiality, say, within the organization on these issues. But now it looks a little bit more problematical. Obviously, context, as we've been talking about, so important about how they've expressed those views and what they've said, and the detailed nature of the role. Lorna, have you got anything to say on that one?
No, I mean, I think certainly it might well merit a discussion, and probably you'd need to look at what your existing policy says in terms of what people can do on their personal social media. But I agree with Michael that if it's their job to be your social media presence, that there may potentially be more of a risk that that the views or that being expressed by the individual could be conflated with the views of the employer, albeit I note it's being done on his personal social media or their personal social media rather than your social media. So I mean I think in the first instance that you know, if it on the face of it conflicts with your code of conduct or social media policy, certainly a discussion about about how that's how that goes on is certainly appropriate, but
Mm.
whether it would justify going on to take disciplinary action, it is again, it's very much a question of context. What is it, I suppose, that you're objecting to? Is it, if it is a risk of reputational damage, is that risk actually manifesting itself? Is anyone confusing their views with the employer's views? Could it perhaps be remedied by making sure the employee places a disclaimer on their posts saying, the views expressed are entirely my own and nothing to do with my employer, if that's even necessary? Yeah. I think it, as I say, it's about conducting that proportionality assessment internally and working out what it is that you're objecting to, and if it's just the fact that some people might be offended, then I think what Higgs and Farmer is saying is that there isn't a right not to be offended. You've got to show more than offence in order to justify action.
Yeah, that's really helpful. The next one is, how does school provide guidance on what expressions of beliefs are appropriate on a private forum if an employee has the right to do so? Well, I guess, I don't know, Lorna, do you want to lead with that one?
I mean, I think I think as with being at risk of repeating myself, I mean, I think the point is that if you know, an employer's ability to limit what an employee says on private social media, it is restricted. So, by all means, you can set some guidance around what, you know, what views you might think are appropriate to be expressed openly. But to an extent, I think, if they want to express views privately, um, and they've got, it's more about, I suppose, giving them guidance about making sure their privacy settings are correct so that these views are not being expressed, and making sure that those private views cannot be attributed to you as an employer. And then actually, if they're just expressing them privately on social media and there is no evidence that it's impacting on the work or their behaviours at work, and there is no evidence that with the privacy settings in place, it's causing any damage to you as an employer, then actually I think where the courts are going with this case is you can't really give them guidance about what they're saying on their private social media. That's a matter for them in their private life, provided, of course, they're expressing or manifesting beliefs that are protected, which, there are. Forstater has made it clear that those, the beliefs that are protected are wider than perhaps we historically thought, but there are still limits to what
Yeah.
beliefs will be protected. So
And that's
yeah.
a really important point, isn't it? This isn't carte blanche for people to be obnoxious and horrible online without any consequences for them within the workplace. We are talking about protected beliefs. And those are wider than they used to be after Forstater, probably. But nevertheless, there is a line to be drawn, definitely. So we've got a few more minutes. So there's a few more questions, so we'll run through those. If she, which I think must be Mrs. Higgs, if Mrs. Higgs was issued with a written warning instead of dismissal, would she still have been able to bring a claim, and would the outcome have been the same?
Mhm.
Well, I mean, that's another really good one, and I think the school would have clearly been on better ground in the proportionality test had they issued a warning. On the specific facts of Mrs. Higgs' case, the court was very clear that they felt that Mrs. Higgs hadn't really done much which could be seen as legally culpable in the terms of the Equality Act and the expression of her beliefs. But nevertheless, some form of warning falls well short of dismissal, so doesn't it? So that may, it's much more likely to have been seen as a proportionate act. Lorna, do you agree, having looked in the facts of it all?
Yeah, I entirely agree. Yes.
Yeah. The next question is, proportionality assessment was expected from the tribunal and not the school, although the disciplinary process had gaps. Well, I think the question is right, is that the school didn't go through that process, nor did the tribunal. The tribunal talked about separability, really. And the higher courts have said you've got to look at the proportionality of it all. And so now I think a school would be expected, or an employer would be inspected, to assess what was really proportionate in the case, looking at the evidence rather than jumping to conclusions about views that many people might find a little bit difficult or offensive. It's actually looking at the objective evidence you have around reputational risk and around the how offensive or otherwise the expression of wishes has been, expression of, not wishes, the expression of belief has been. Anything on that, Lorna, before we move on to the next one?
I suppose only to say yes, in order for a tribunal to decide whether the action was subjectively justified, it's required to, to conduct a proportionality assessment. But obviously, if the school doesn't or hasn't done that, it's far more likely, if it hasn't done it itself, it's far more likely to fail that proportionality assessment when it's did by the tribunal. So it's sensible, I think, yeah, as an employer, to try and undertake that assessment yourself.
Yeah. Okay. Please could I clarify, in Mrs. Higgs' case, does her lack of belief that a person can change gender not constitute a transphobic view? My understanding is that transphobic beliefs would not be protected beliefs. What is it about Mrs. Higgs' views that makes them not transphobic in nature? Well, this is a difficult area, but I'm going to leave it to you, Lauren. But I think the headline was that Mrs. Higgs expressly stated that she was not transphobic, and there was no evidence of that in her work, was it, for the purposes of the of this case?
Absolutely. And I think what Forstater said was that, gender critical beliefs, so a belief that someone can't change gender, are protected. That was expressly found in the Forstater case. And whilst you're absolutely right that transphobic beliefs would go, I think applying Forstater and Granger would go a step too far and wouldn't be protected. I think it's about the level of so someone has a right to believe that someone cannot change gender, but what someone wouldn't be protected in doing is therefore trying to incite hatred towards someone who believes otherwise. It's about, it's that's if you go there, if you cross that step, and that's when it becomes transphobic and therefore would cease to be protected. Is my understanding of where we're going with the current case law and applying the Granger test. It wouldn't be worthy of respect in a democratic society, and it would fundamentally infringe the rights of others. It's that fifth Granger test, yeah.
And it's in terms of the expression, I think there have been cases to date prior to Higgs as well, where expressions of views have been, one can take two extreme examples of someone who has gender critical views, but it expresses those in a way which is respectful of everyone else's views, for example, in a very proportionate and measured way, and someone on the other end of the spectrum who rants in a sort of polemic way, and in a way which incites, as Lorna said, hatred for particular groups, or even personally declares their dislike or hatred for those groups. That expression will probably cross the line, won't it? Well, probably it would cross the line, and certainly in terms of then how that works in discipline and disciplinary context within the school, that would be part of the context to be taken into account. In the Higgs case, the court found that she'd fallen well short of that sort of behaviour. So the next point, got a few more minutes. This question starts with an apology that the question might be slightly off-piste. But it's about the previous question is specifically in relation to social media online hustles, i.e. influencer type side hustles. Lorna, do you want to start there?
Yeah, it's a tricky one, this one, because again, it's about that really careful balancing act, because I think in this age of social media influence, there's a huge rise in that, and so there is a more risk that employees may be doing these kind of things on the side. I think I mean, I've been involved in a case where the claimant had had, aside from her job, a social media influencing presence, and it was within that context that she was posting things that her employer found inappropriate. I think if you if you're, I mean, if you're as an employer, someone who says you mustn't have other secondary employment or secondary forms of income unless you've disclosed them to us, we need to be aware, and all those kind of things, then, you know, actually you probably do have more of a right to exert some influence over what goes into those side hustles, as it were. But that sort of depends very much on the nature of the employment as well, doesn't it? You know, if it's someone's in, you know, part-time role, junior role with you, I think just it is probably largely unreasonable to dictate what they're doing to earn income elsewhere. But if they are in a senior position with a you know a large income with you, your ability to reasonably control what they do outside in other employment or other income making spheres is likely to be far more proportionate. But yeah, if the side hustle is generating income for them and isn't and other income generation isn't prohibited, I suppose to an extent, um, it's possibly more disproportionate to try and stop them saying certain things in that side hustle because you would be potentially affecting their income stream, and that seems like a fairly large infringement by you as the other employer. But on the other hand, I suppose the fact that they are a social media influencer with lots of followers therefore means that they're likely to have a very large audience. So to the extent that there might be actual damage to your reputation if those views were conflated with the employer's views, obviously there's a far greater risk of that happening, um, because it's going out to a much wider audience. So, in some ways, it sort of is against your interference. In other ways, it's quite pro your interference. Um, I think it's very difficult to set a hard and fast rule. As I say, it's context specific. But if it's a teacher, I mean, if they're a full-time teacher working for you, and I suspect, you know, your code of conduct it may well be reasonable within your code of conduct to say, I mean, personally, when you've got to bear in mind things like teacher standards and those kind of things, it's entirely reasonable to ensure that, you know, the standards of faith in the teaching profession are upheld. So you'd be able to certainly regulate what's said to that extent. I think that would
Yeah.
largely prevent them from promoting, you know, very offensive or inflammatory views anyway.
Yeah, I
That
mean,
helps.
yeah, these are difficult questions, and they're difficult to talk through in the absence of detail, aren't they? But if one imagines a teacher who had a side hustle of expressing very strident views in order to, you know, obtain notoriety or whatever, or within a social media presence, then one can imagine that the balance might be shifted further inside of the employer in terms of disciplinary or other action, as compared to the case in Higgs. And certainly, I suppose the underlying message is that Higgs doesn't stop, does it? Disciplinary action or dismissal in cases where people have expressed offensive views, which which are, you know, based on protected beliefs. It just means you've got to be proportionate in the way that you go about doing that and take into account the evidence you have about reputational harm and other things. So I think the final question now, which has got a couple of minutes left, is if an individual's work specifically requires them to express beliefs about a situation within an academic context that is in total opposition to those of another person, is that likely to offer them protection on those beliefs when viewed in light of the Higgs case? So where their work specifically requires them to express beliefs, I guess this is wrapped up in the wider debate of academic freedom, and if somebody's job in terms of their academics is to have the freedom to have those beliefs, then it's less likely that you're going to be disciplining people for that, isn't it? It's normally where people are on what lawyers might call a frolic of their own, separately in a private capacity, expressing views which are not really related to the proper conduct of their duties, is what we're talking about here, which is what Higgs was talking about. I don't know if you've got anything to add in a final minute or so for that, Lorna.
No, not really. Thanks. Yeah, I think I'll bow to your superior knowledge of academic freedoms in higher education sector. Thanks.
Okay. Well, that's great. Well, I think probably we'll call an end to it there. Thank you so much for your questions. They were challenging and interesting as ever, so thank you for that. I've no doubt that this area will continue to raise all sorts of context-specific issues for us all to think about, and will be pretty challenging over the coming years, and we'll see whether the matter goes to the Supreme Court or not. If it does, probably we won't hear back from them for a long, long time. So we're stuck with the Court of Appeal for the moment. Anyway, I think for now we'll just say thank you very much for attending, and hopefully you will log into next month's webinar. Thank you very much. Bye-bye.
Thank you.